Hi, this is Nick from the Law Offices of Travis Walker. I am sitting here with our founder of this law firm,
How you
Travis
doing, man?
Walker.
Good to see you.
Good. This is the TRW Law Podcast. Today we are coming to you with the topic of divorce. So Travis, do you want to go over divorce real quick and what exactly it entails?
Sure. So here in the state of Florida, particularly, it's a no-fault divorce state, which is a lot different from a fault divorce state. Fault divorce states typically you have to prove adultery or some type of abuse or something like that. Here in the state of Florida, the basic term is called irreconcilable differences, and that's the term by which you can get a divorce. And typically speaking, that means just about anything under the sun. So a divorce is obviously when two people are eliminating their marriage and they're stopping their marriage, and we help them out here at the firm.
Okay. When did you receive your first divorce case?
Oh gosh, probably 2000. I've been practicing since 2007, so helped out with some divorce cases all the way back to 2008, 2009, some big time divorce cases. And then when I went out on my own in 2012, that's one of the practice areas that really started to generate, and felt a calling for it because especially divorce is a very emotional, difficult time, and looking to help people out because it's not an easy process, and that's what we're here for.
How do you feel like working on divorce cases has shaped you at all as a lawyer?
Well, I think really, we talk about attorneys being counselors at law, and so really, I don't know if there's a better place to be a counselor than perhaps in a family law arena where you're dealing with people with highly emotional issues. So it's really shaped to be more empathetic and compassionate to the clients because I know they're going through some of the most difficult and challenging times of their lives, and we're here to guide them through it as effectively as possible.
Okay. So for this segment, we're going to start discussing the divorce process and what exactly it entails from the start.
Sure.
All right. What are the grounds for a divorce, and how exactly does one go about initiating the process?
Sure. So divorce here, the grounds for divorce can be basically irreconcilable differences, which is what we talked about at the beginning. And so when someone would do would be filing a petition for dissolution of marriage with the court system. There's a few different varieties of petitions for divorce, but your standard petition for divorce is one that is filed with the courts. You serve it on the other party with a process server or the sheriff, and then they have 20 days to respond, and then that's what gets the divorce rolling.
Okay. So a question I have for you is, what's the difference between a fault-based and no-fault grounds for divorce?
Sure. So like a fault-based is adultery or abuse or desertion, those types of things. There are different states in the union that provide for that type of standard requirement. Some require a certain number of months of separation or a year of separation before you can start a divorce. Here in the state of Florida, all you have to do is file for divorce, and the judge can actually grant that divorce within 20 days, after 20 days, and that's all that's really required.
Okay. So I know that some people, they legally separate before they actually get divorced. How does the legal separation process ensue?
So like in other states, like you're married and then there's a separation, you can be legally separated, or there's divorce. There's also common law marriage in other states, but in Florida, you're either married or you're divorced. There's no common law marriage, there's no legal separation standard. You're either married or divorced, and so there's no real gray area. You're either married or divorced, and then that's when the process starts to the divorce.
Okay. Can you explain the divorce petition and its contents in more detail?
Sure. So the petition for the divorce kind of sets forth the standard, obviously the irreconcilable differences. It provides some personal information with regards to both of the parties. If there's children involved, it names the children. If there's property involved, it usually references that. If there's going to be the sale of a property via partition, that's a separate count in the divorce as a partition. If there's certain equitable distribution, that has to come into play. The alimony question and attorney's fees often comes into play as well. The need versus ability to pay. And there's some art to it. There's certainly some standards that need to be in that petition, but there's also a little bit of art to it, depending upon how you're handling divorce and whether or not you're handling it in a very aggressive manner, which we certainly can do, or you want to be more conciliatory and collaborative, and that can be done as well. It just really depends. Here at our firm, we really think that giving the client a lot of a direct discretion with regards to the temperature and the aggressiveness of the file is important. Obviously, the more aggressive you are, the more fighting there is, the more legal fees there can be. So you just want to be sensitive to that. But at the same time, you also don't want to roll over and just give up on everything too.
I wanted to interrupt this segment with a question that we received a lot in the comments, especially pertaining to divorce, is do most judges prefer a more aggressive approach to representation of a client? Do they respect more of a passive approach in regards to the way you just go about your case as a whole?
I think, the judges understand that we're zealous advocates, and lawyers, we're trained to be zealous advocates and aggressive. There's obviously a point position where we can be overly aggressive, and it actually it causes an impact to judicial economy. So you want to be sensitive to that. At the same time, like you can't just roll over on for your case, for your file and your client and everything else like that. But I do know that the judges primarily want to see these cases settled out as opposed to going to trial. So sometimes I've been in cases involving 1, 2, 3, maybe even 4 mediations, just to try and see about resolving it before it goes to trial. So the judges will often try to get the parties to come to mediation and settle the case.
Okay, that's very interesting, actually. For segment 2, we have property division.
Sure.
Property assets is a very big thing in divorce.
Yep.
Since I've started working here, I have learned how much people care about the things that they've attained in a marriage.
Yes.
Yes. So the question I have for you is: property division is often a complex and continuous aspect of divorce. How are marital assets and debts divided?
So, I mean, we come with the idea of 50-50, and it's actually funny, Jeffrey, who works here at the firm, he kind of equates it to, it's 50-50, but it's like not like you're cutting a cake with a knife, it's more of like you're taking a baseball bat to a cake. So like, it can kind of go everywhere, right? And so while you start with this kind of premise of 50-50, you start also getting to things, okay, this was acquired before the marriage, or this was acquired with, family money, or there's a trust involved, or there's probate involved, there's wills involved. All these things can come into play. And so while there's like this idea of like 50-50, I did more work on the house, I paid for the mortgage and the taxes and insurance, you did nothing. So it goes on and on. So it starts with that premise of 50-50, but equitable distribution can get very messy very quickly.
Okay. I'm gonna be very honest with you guys. Now that I have Travis here, he's always a busy guy, so it's nice for me to be able to ask him certain questions. So a question I have for you is, in a divorce case that you've worked in, what have you seen the client you're representing and opposing counsel, like something stupid that they fought over?
Anything from dishes to furniture to cats and dogs. I mean, don't get me wrong, cats and dogs. Everybody loves their animals.
Member of the family.
Member of the family. But I mean, things that are generally replaceable. I mean, rooms to go furniture and stuff like that. We're not talking about heirlooms. And there's just it gets to a certain point where it's just like, okay, are you going to spend hundreds of dollars per hour for an attorney to fight over this, or you're just going to just say, I'm going to save that money, I'm going to go buy it on the back end or something like that.
Which makes the most sense, but.
You've seen and in the law we always see, I tell this is you're trying to make rational someone rational who's being irrational, and that's kind of the process of working through divorce.
Okay. So another question I have for you is, can you explain the difference between community property and equitable distribution systems?
Sure. I mean, we're here in Florida, we're equitable distribution, so it's that 50-50 equitable distribution. So that's an important process. Community property, which I believe is more like in California, it really kind of creates its own, like, there's not that 50-50 presumption. It's what the courts decide. Another thing I understand in California is that, when you're going to mediation, the mediator actually kind of decides your case. Here in Florida, when you go to mediation for divorce, the mediator's there just to try to facilitate some type of an agreement, but in the end, isn't making some type of decision on your behalf.
Okay. How do you determine which assets are considered marital property?
That's a good question. So obviously anything acquired during the marriage comes with like this presumption that it's marital. Anything that, we've seen this over and over again, if someone has a piece of property before the marriage, they get married and then they put the other spouse on the deed, that creates some issues with regard to marital property, and that's always been like a big stick. It gets very sticky very quick trying to get them off of it. So there's always that marital property question, and that bright line of when the marriage happened obviously is a big determiner of that. But then if you have an asset from before the marriage and then another party is actually contributing to the asset, that's when it can get a little sticky.
So in a marriage, let's say a wife buys a car, her husband is a stay-at-home husband, and in the divorce he tries to take the car that she purchased. Is there any way that he would be able to get that car from her?
I mean, it's quite possible. You know,
Wow.
if like, you know, he's, you know, if it was acquired before the marriage, it's a little bit more difficult. If it was acquired during the marriage and there's equity in there, you know, he's going to try and make a play at it. You know, and then it gets into all the little questions like, well, did he do the oil change? Did he do the maintenance? You know, all that type of stuff. So it can get really interesting really quickly.
And those are factors when deciding something like a vehicle, is how many oil changes were done, how many times you did it versus I. Wow.
Yeah.
Okay.
It gets pretty crazy.
That's that's very interesting, honestly. Just as you guys are learning, I'm learning too. That I'm fairly new to a lot of this, so the fact that I'm even hearing some of these things is information that I'll hold for a very long time. Our next segment that we have is spousal support, which is a very big thing.
Yeah.
Spousal support is also known as alimony, is another critical consideration. How is the amount of duration of spousal support determined?
That's a great question, and so the law recently changed as well. And there's specific number of years of the marriage, and then there's specific, you know, the alimony is calculated. So that's been interesting because I've been practicing for 16 years, and just recently they got away from permanent alimony, and now we've gotten to more of a structured way of doing it. But really, alimony has always been need versus ability to pay. So like, you know, the need of one party versus the ability to pay the other party. And then you have to figure in things like, you know, once child support is taken into place or a house is taking in, and alimony is, there's a lot of statutory criteria that's in the statutes, and then there's a lot of case law that interprets it, because alimony is definitely a heavily litigated issue in a divorce, especially long-term divorces, and so it becomes a big issue very quickly.
Okay. So a question that I have for you is, what are some common types of spousal support arrangements?
Sure. I mean, now that we've gotten away from permanent, you know, you got the bridge the gap, you got periodic, you got short term, you know, you got rehabilitative, you got a number of different alimonies still available. So, you know, the purpose of alimony is basically either to help them get back on their feet or to give them some support for a while. And so you can really structure in a number of different ways. Sometimes, you know, you can use the house, and then like instead of a large amount of equity going to, you know, and splitting it down the middle, one party maybe get a little bit more alimony. It just depends on all those factors, and that's the gray area that we fight in. Okay.
So with this new law that's come into effect, do you feel like it'll affect, because a lot of people like to look at things from a male or female perspective.
Sure.
So do you feel as that it will affect males or females more in these situations?
Well, it's an interesting question, because like, you know, I think, you know, it had this law passed like 20 or 30 years ago, I think it would have impacted differently than it does now. The workplace has changed a lot. Women are making more and more income, and we're actually finding times where we're like obviously getting child support paid from the female to the male, or alimony paid from female to the male, that type of thing that's usually not typical, but it's becoming more and more common as women, you know, really prevail in the workplace, which is great. And but it, you know, it definitely flies in the face of which is normal. And so, you know, it's going to be interesting to see how this law plays out.
Interesting. Okay. So based upon your 16 years of experience, what is a amount that you've heard on spousal support that you personally feel like the opposing counsel didn't deserve?
I mean, like it could be anywhere over the place. I mean, it litigated a number of divorces and gone to trial, and the judge awards something which is way outside of what it should be. And you know, the contributing factors, you know, the alimony is really that need versus ability to pay, and so child support, you know, payments from one to the other should be taken into account. Income from retirement assets should be taken into account. So all of that, there's been a number of times, which is why, you know, you'll hear judges say, hey, I think you should try and settle this case so you control your own destiny, because sometimes you get in front of that judge, and I tell my clients all the time, it's like, hey, there's 9 Supreme Court justices for a reason. They see the law differently, they interpret the law differently. So you have no idea what you're going to get with one judge, and you're not going to know, with that same judge, it could be different from one week to another. So it's hard to say.
Okay. Are there any tax implications associated with spousal support payments?
Yeah, I mean, you definitely want to talk to your CPA about any issues with regards to taxes. You want to negotiate that, put that into the marital settlement agreement so it's perfectly clear. I think one of the biggest mistakes that a lot of our clients do is, and sometimes they do it because they do the divorce on their own, and you know, that's you know, you have the ability to represent yourself in a divorce, but if you don't have a very airtight marital settlement agreement on a number of different levels, not just alimony, but kids and everything else, you're going to come back and be back in front of a judge to interpret that ambiguity and some of those loopholes and that type of thing. So it's you definitely want to get some experts involved to determine what it would be like, what your long-term prognosis is.
To tie this in, what you've already spoke about is you started talking about child support. So, number one, with child support, how is child custody decided, and what factors are considered?
So that's a great question. So child custody is primarily, what is in the best interest of the children. That's the overarching theme for children in the state of Florida. But more importantly, along with that alimony bill there was a 50-50 presumption for time sharing now. So unless you can overcome that presumption, you're going to be with a 50-50 time sharing. And I think what a lot of our clients and people in the state of Florida, they've raised their kids very well. And then if one of the kids is like a little bit behind in school, or forgot their backpack, or the other side was half an hour late, that's in comparison to what the judges see, like from an abuse standard. They see the worst of sexual abuse, they see the worst of physical abuse, they see the worst of emotional, mental abuse. To compare that to whatever issues are in front of the court at that time, oftentimes they pale in comparison to what the judges are seeing from humanity. And so they oftentimes, one, don't see it as an emergency if you think it's going to be an emergency, and two, they just don't think it's like a big issue, and they kind of they don't take it up as seriously as you would. Not to say that it's not serious, but because of their perspective, that's something you have to be concerned with.
Okay, so this is another one of my questions. So how exactly is it where in a lot of cases you'll see a parent who is best fit to have that child 100% of the time, and they still might get granted 50-50, or the parent who is obviously the most fit won't even get any time with their child? How exactly does that work, and why do cases like that even happen?
I mean, it's a great question. I mean, and that's the problem with the legal system, is it's not perfect. And so, again, the judges, everyone comes in with what their experience has been like in their life up to that point. And then judges are the same way. And so that's why you have liberal and conservative judges and that type of thing. So oftentimes you'll find there's circumstances that you're like, wow, how did that even happen? And what you see is like either maybe some evidence didn't come in, or the evidence rules didn't allow for that evidence to come in, or the judge didn't see the evidence the way that was intended. And so oftentimes that can happen, and sometimes the decision isn't the right decision. But that's why there's a big push by judges and attorneys to get to mediation and try to settle it in a way that's, you may not get everything you want, but you're going to have more certainty that it's going to be controlled and in a better place for the kids.
Okay. It it's honestly, with hearing a lot of this information, just to hear from your experience and what you've seen and or heard, it opens up your eyes, because especially for our listeners, there's maybe some things that they never even knew about divorce, that the information you're sharing right now is an eye-opener to them.
Sure.
So that's exactly what it is for me.
Yeah.
Another question we have is, how is child support calculated, and what exact expenses does it cover?
Sure.
In most cases.
Yeah, I mean, and child support while it goes from one person's bank account to another person's bank account, it's really for the child. So there's a child support guidelines worksheet in the state of Florida. It's primarily about overnights versus income. And so that, in conjunction with health insurance contributions and daycare contributions and those types of things, determine that guideline calculation. But your overall calculations is going to be based upon overnights versus income.
Okay. So the next thing we have is, with custody arrangements, when does it get most difficult with trying to come to a settlement on what exactly is going to be done with the children?
I think, everybody's got their own, way, and, sometimes opposites attract, and then you have people in a relationship who've created children who don't necessarily have the same philosophies, and then that can create, big issues. I've represented people in Jehovah's Witness or different things, but they're not, together with somebody who is, and then there's a conflict later on, and there's a lot of different types of things where there can be conflicts, whether it's religious or medical, or where the kids go to school, or when they go to bedtime. I mean, what basketball team the kid's on, all those things can create conflict if the parents allow it to become a conflict.
Yeah, because in a lot of cases you do see sometimes where, like when my parents were getting divorced, they made sure to understand, like, I need to be as neutral as possible. I don't need to pick my mom's side or my dad's side. At the end of the day, they both took the time to pour into me as a child, so they both should get time with me. One parent isn't bad talk the other, and I feel like in a lot of cases you do see that where the child grows resentment for whichever parent is quote unquote in the right in the situation. So that also plays a very big part in the custody arrangements. But with custody arrangements too, obviously when the child gets a higher in age, when does their say actually matter?
It depends. And so like every judges are different. I mean, my experience with most of the judges here on the Treasure Coast is that they really don't want the kids' involvement. So like even if the kid's 15, 16 or 17 years old, it becomes it's more easy to get them in front of the judge and say, hey, this is what I think, this is what's going on. But the judges are really reluctant to bring a child into what is can be a very intimidating, very stressful atmosphere, and then in a very combative atmosphere too. And they don't think, and the judges go to judges school, they're constantly learning and everything about psychology. And I think they've really learned that it's not in the best interest of the kids to be involved in a divorce. Even if like the kid has a very, very like adamant saying like, I want to go with dad or I want to go with mom, the judges are very reluctant to allow that to happen, absent some very special circumstances, and you better have some special circumstances to even ask for it.
Do you ever has there ever been a case where a judge has had to speak to the child behind closed doors to see how they feel about the way things are going?
I've seen it happen. It's very, very rare. You see it a little bit more in dependency actions, which is where the abuse cases and stuff. But generally speaking, yeah, I mean, it's not something that happens very often, but it can happen.
Okay. So moving on to the next thing, we have the role of mediation and litigation.
Yes.
All right. So when it comes to resolving divorce matters, what role does mediation play, and when might litigation be necessary?
So, I mean, the litigation starts the divorce. Mediation is always going to be required in divorce, especially here in Florida. And so, like I said before, it can happen 1, 2, 3, 4 times, depending upon the length of the case, how vexatious the litigation is. I was talking with another attorney here, Nick Brehammer, and he was telling me, like, you can have legal fees into the 7 figures, which means that it was like super contentious, super crazy, everybody's fighting over everything, and that often leads to several mediations. And that especially is involved if you have business owners who own their own businesses, and then you have forensic accountants and that type of thing. So mediation is a huge part of the process. I think that the most recent number is like 97% of cases settle before they go to trial. And I would say the vast majority of that settlement occurs at like a mediation, as opposed to the attorneys trying to get together and settle it. Because the mediation is helpful because it puts everybody in the same room together with the whole purpose and focus of getting the case settled. So it's just a nice opportunity to get it done, as opposed to continuing to spend time, energy, and money on litigating the divorce if you can just get it done and over with.
So in mediation, what do you feel like are some misconceptions that people have about mediation?
I think, mediation, some of the misconceptions they have is that it's kind of like a decision, like they think they're like a judge. Sometimes there's a judge who is the mediator, or a former judge who's the mediator. And so, like, you have that there, but just like I was saying, California and Florida, California actually has a mediator who makes a decision, where Florida, they're just trying to facilitate a decision. So sometimes I think they think they're coming to the mediator to kind of present a case. Like, they're like, hey, I'm going to argue my case, make sure you hit these points with the mediator. The mediator is there, of course, to hear the points and to understand and everything, but ultimately it's not like they're going to ring the gavel and like determine the case. They're just there to try and facilitate an agreement to the best possible that they can. So I think sometimes people think that a mediation is a form of a trial, but it's not.
Okay, interesting. Because I know that with, obviously from working here, I've seen how important mediation is, the prep work that mediation takes. So like you said, the legal fees that can come from going to litigation, I couldn't even imagine how some people can't even get it done in mediation with how much it actually takes to get to that point of litigation.
Sure.
Yes, sir. So what are the benefits and drawbacks of choosing mediation over litigation?
So, I mean, obviously, if you continue to litigate, that creates time, energy, and money. If you mediate, one of the pros is obviously that you're going to be able to possibly settle the case, save yourself time, energy, and money, get the stress of being involved in a divorce and litigation behind you, and then move on with your life. One of the cons is that mediation is time containing. You have to prepare for it, you have to attend it. It's a complete waste of, sometimes it's a complete waste of time. I mean, it's necessary and required by the courts, But you could go and spend hours and hours there and then not come out with any settlement.
Mm-hmm.
That being said, usually at least you created some fence posts at mediation. If mediation comes to an impasse where there's no agreement that comes into play, at least you kind of know where you are and you know where the other side is, and maybe the fence posts have moved in a little bit, and that can help facilitate a future settlement discussion.
Okay. Well, that is all we have for today, Travis. I wanted to thank you for taking the time out of your day to even be able to speak to me and our guests who are watching.